Laws need to change. They become unjust over a period of time. Can laws remain in a permanent flux? Changing from time? Should we rely on you? Say loudly what is this?
Yes.
Homes. What is it? How is law defined by homes?
Judges and advocates decide.
Studied law precedent? Yes. So, when a court rules something, does it apply prospectively or retrospectively?
Sometimes it can also
Now, see, the decision is given in a case. The precedent has arisen in a case. In respect of a dispute which took place years ago. So, what is the court doing? It is saying that years ago, X was wrong and Y is right. Right? Is it prospective or retrospective? Retrospective. Because it is declaration of law. When court rules, it declares the law as it existed when the dispute arose. Right? Is it just that you are telling me after years in the court that you are wrong? I relied on the law. After years you say that that law is unjust. We interpret it differently. Or we simply set it aside, say nullify it. What happens? Is there certainty in law? What should a litigant rely on? I can't read this, you can. Yeah, you don't have to read it to me. I can't read it because I don't want to strain my neck. So therefore, the second part of legal order, which deals with breaches, we need to talk about that legal order also. One caveat I entered just now. Don't accept anything that is said here or by me as gospel of truth. Question it. Say that no sir, this is not correct. Your analysis is wrong. And only if you are convinced that what is said is correct, then go ahead with it. If you have to be good lawyers, good judges, you have to question everything. Question even the provision of law. Whether it gels with time or not. There is a small nursery rhyme, I don't remember exact words, but you may. Because there is a time for everything. Time for sleep and time for work. But the actions and time must fit, isn't it? Something like that. So therefore, actions and times must fit. With time, things changes. Therefore, our actions, our steps which we take as lawyers must be in tune with times. And that is the biggest threat to the certainty and continuity of law. Right? Somebody said precedents operate prospectively. Who said that? Or all of you said that? When was the first time that the Supreme Court said that precedent will operate prospectively? This particular judgment of ours will operate prospectively, not retrospectively. For the first time, Supreme Court said this. They said it will operate prospectively. See, this was about food adulteration when the first time Supreme Court used prospective overruling. In Babmani's case, there was certain ruling which they overruled in Agesari Muhammad versus State of Kerala. They said that this will operate prospectively. But otherwise, normally, every ruling operates retrospectively. Now, in this talk, I am going to advocate a change because the legal order is really not just. The basic defect in lawmaking is that it lays down law or legislature devises a solution for a problem which has already arisen. Right? Why do they make law? There is some problem. Mischief rule? Yeah, interpretation of statutes. So, mischief rule you know. So, what was the mischief which was to be dealt with, and therefore this law is made? All new laws are made like that. No? There is some situation for this law is made. Now, how far can this lawmaking go? For every mischief, you have to provide some rule. And then you find after some years, no. This was not really mischief. 377 considered to be mischief. Now it is not considered to be mischief. You make a rule and then you find that the rule is not in tune with times. This is a gross example. But the extent to which lawmaking can go and the problems that it can cause. There is a recent example, you must have read in papers if you keep a track of things, that the government of India made rules about admission to ICUs. Recall Munna Bhai MBBS. For Marna Padega Kya. Now for admission in ICU, doctor has to look into rules. Whether I should admit the patient or not. Now this is a decision which the doctor has to take within a second. When the patient comes, whether the patient goes to ICU or not, has to be decided in a matter of second. Otherwise the patient may die. But why was this need felt by the government? Why did the government of India, or suppose you are the government of India, why would you feel the need to have rules for admission to ICU? Yes. Yes, Edmund.
So there must be some mischief regarding the admission to ICU. That's what we did.
So what is that mischief which you have seen in newspapers? Who gets admitted to ICU first? One who has money. One who has the money. One who is convicted by a court or about to be sent to jail. Right? Huh? So they immediately go to ICU. And then when a patient is really in need of being sent to ICU, there is no bed there. And the patient has to be on the floor of the hospital, taking his last breath. Therefore, the government of India felt that rules for admission to ICU have to be made, right? So that people who need ICU will get it, and people who want to use ICU as a tool will not. But then my question is, how far, to what extent can we take this rule making? Can we make rules for everything? And can we go on changing the rules every day?
No, sir.
And then, basically, the question remains that if the rules are supposed to be governing conduct of people, if people are supposed to know the rules, we need to put the rules in place for somewhere. That this is what you are expected to do. Now, can judges of Supreme Court claim that they know all the rules? I have spent my lifetime in courts. I can't claim that I know all the laws or rules. I can't. Nobody can. You know only that area of law which you have dealt with, actually dealt with. Otherwise, reading a textbook does not tell you law. And as for that matter, your syllabus does not cover all the laws. Syllabus only tells you the geography of law, where to find which provision. Nothing beyond that. Therefore, ignorance of law is no excuse now. But it's impossible to know what is the rule, what is the law, at the point when you are supposed to be acting. If that is so, how are you going to achieve rule of law or just legal order? So therefore, on the first count itself, the legal order fails, that it does not have a clear direction to common man, to litigant, to lawyers, to judges, as to what is the rule. And therefore, what happens is, courts decided, then courts step in. Because legislature has left a vacuum, or the interpretation which the court has done in the past is not in tune with times, therefore changing. No adultery judgment.
Supreme Court has nullified the adultery, and the latest they have made ABC a punishable crime.
What was the first judgment on adultery? This is the latest law. This is the latest law. But what was the law before this? Why was Supreme Court required to rule this? So the provision of law was already there. Why was the judgment required?
The males were in that particular males were only what they committed for adultery as a criminal offense. Even if female initiates it, that time also the another male is convicted for adultery only. So there requires a change that it become non-criminal offense only a ground for.
Three of your friends on that side want to speak. Yes, one by one.
Firstly, it treated the woman as the property of the man, her husband. Secondly, it did not consider that woman could be the one who had initiated the relation. Instead, the person who she had relation with would be the one who is punished. And thirdly, it was discriminatory because she could not file the complaint against the woman who was having a relationship with her husband. So it was in sense only for the men to file a complaint against his wife's relation, but not the other way.
Yes.
Proving adultery was next to impossible because we have to prove leaving adultery. So, in practical sense, both the parties engage in litigation that will last forever, and the benefit was of none. Also, the logic behind decriminalizing it might be that proving adultery is more of an impossible task, and thus it is the only ground for divorce as of now.
Yes.
Sir,
adultery was struck down in the case of Yusuf Sheikh versus Union of India for first time. The reason behind it was
Year, first time year.
Uh,
Year. Which year?
so I don't exactly remember the year, but case name what is I remember. So basically it is discriminatory. क्योंकि उसमें होता क्या था कि फीमेल जो है वो हस्बैंड के खिलाफ बेसिकली मैं 497 पहले क्या है वो मैं बताती हूँ फिर उसके बाद
नहीं नहीं वो ऐसा कीजिए. You are doing your 4th year now, no?
नो सर आई एम पास आउट
Passed out. Again, you are doing your again.
pursuing LLM.
Great. There is a principal sitting behind you. He will definitely engage you as a good teacher. Very good. So, reserve it for the time being. Yeah, please. Young man, 4 ladies have taken time. So, anyway, you can.
There was one thing apart from all these that the court had adopted a liberal approach to decriminalize adultery because of the changing needs of the society. The court considered that adultery should not be a crime.
Okay. Justice Chandrachud overruled his father. There was an earlier judgment of his father, Justice Y.V. Chandrachud, on adultery, which was overruled, right? Read both the judgments. Now tell me, this judgment, adultery, fresh new judgment, is it for the benefit of men or women? Does it protect men from indulging in indiscriminate relationship with females, irrespective of whether they are married or not? Right? Who is liberated? In this judgment, who is liberated? Huh? Loudly, what is there? Were females anytime victims of that act section? Could they be punished? No. So who is liberated? This is the fun of law. You say that you are doing something for the benefit of women, and in the garb of doing something for liberation of women, what has been done? Who is free from punishment now? In the earlier law, were women liable to punishment? No. Then what is the advantage? This is the fun. Of course, it's not a surprise. Heard of Jonathan Swift?
Yes.
Loudly. Gulliver's Travels. What does he say about precedent? Jonathan Swift, the satirist of which century? 18th, 17 something. Okay. So, Jonathan Swift says about, so even if you remove this, I think I am audible. Professor, you are able to hear me, no? For the sake of recording only, this is required. Otherwise, I am okay with a class of 60, 70. Swift. Yes. Exact quote, it is lost in some paper somewhere. He says that it is a maximum of lawyers that they record their reasons, their judgments carefully, which are against common reason of mankind. Whenever they have to do something which is against common reason of mankind, they meticulously record it and call it precedent. Otherwise, why is precedent required? If it is logical, if what you are concluding is logical, why do you need to say that Justice Holmes has said this or Justice Chandrachud has said this. No need, no. You logically come to a conclusion. You don't need to invoke Tukaram. Baba Vakya Pramanam, not needed. But because we don't logically conclude, we going for precedent. And what happens? Then there is a plethora of precedents. And the judges and lawyers are lost in it. Lawyers, of course, make a mail. When there are too many cases, they just throw the bunch at the judge and ask the judge to sort out the case. This is not what I am saying. Justice S.B. Sinha was judge of Supreme Court. You must have read his judgments. They contain a lot of citations. Okay. Justice Sinha and Justice Pasaya, their judgments are like encyclopedias. They contain everything on the subject. Right? Because this is what Justice Sinha says. This was in a public law lecture delivered at the National Judicial Academy, published in 2015. He says, does our Supreme Court speak in one coherent voice? Can we have 25, 26, 27 Supreme Courts in India? Because at that time the strength was 27 when Sinha was a judge. Can we have different benches of the same High Court taking extremely conflicting positions on questions of law which are of national importance? Doesn't the development of law, imparting clarity to law, require the judiciary to function as an institution? If judges themselves are not sure of exactly what is the law covering a given situation, how can lay persons be expected to know what is expected of them to enable them to follow it? This is what a judge of Supreme Court observes. That we have made a muddle of law, created a lot of confusion, and in the name of precedent, we follow it. So therefore, the entire gamut of lawmaking by legislature as well as judiciary needs to be looked into, whether it serves any useful purpose. If certainty of law, if need for common man to know law is the reason for lawmaking, it has no supporters. Failed. Isn't it? Lawmaking has failed. Either judicial lawmaking or legislative lawmaking. Because we always look into the past. All laws are made on the basis of past experience. And past experience is never a guide for governing the future. What has happened in past is not going to necessarily happen in future. We take the path of Mahajanas. There is a Sanskrit couplet. Go by the path which Mahajanas have taken. Okay, no issue. But that path may not necessarily lead to the goal which you have in mind. That path will lead to the place where the Mahajan had gone, not where you want to go. And it's a question of your future, future of all of you, where change is the order of the day. And changes are taking place with such a huge, tremendous speed that I don't think any lawmaking exercise can keep a pace with it. Law cannot keep pace with it. Always gagging behind. Who has said this? Law is a fellow companion. Always gagging behind. Find out. Okay. So this is also not new, old. Lawmaking in an exam attempt to cover all loopholes in law will have no end. This will be an unending exercise and you will never be able to cover loopholes because what happens when laws are made? Just as about adultery judgment, I pointed out, who has been liberated? Male. What was the object of that judgment? Yes. So, exactly opposite result is achieved, no? So, when you try to cover loopholes in law or make a law, who gets bound? Young men on this side, because my face is on this side, so they are getting all the attention. You are not getting the attention. Who is benefited by making a law? We are very fastidious about definitions. We want everything to be defined. So, if something is defined, what happens? Yes. I am just trying to put questions so that I don't put you to sleep. Yes, Agman, right? Trying to put questions to avoid you being, avoid singing a lullaby. So, who gets benefited by having definitions? Yes, please.
The government.
The government. Anyone else?
So maybe everybody who is government also advocates layman judiciary, everybody gets a proper definition of something that is which is needed. So just anti-government only.
Okay. Now consider this argument. You can reject it. The moment you define something, you get bound by that definition. And I, lawbreaker, am free to find out how I can circumvent that definition. Right? So definition leads to you are shackled. The state is shackled. Law-abiding citizen is shackled, not the lawbreaker. And it's not always lawbreaker. One who needs to find a path. One who needs to find a path in a situation will be shackled by that definition. So therefore, you will find what is the best way of circumventing that. Any aspirants for IAS, etc. Great. So I had the good fortune of going to the Lal Bahadur Shastri Academy for interacting with young IAS officers, evaluating their performance. So they are also struck up, no, with so many laws which they have to follow, and they have to show the result also, because a sub-divisional magistrate cannot allow property to be burnt or loot and arson to go ahead before his own eyes. So what does he do, or what does she do? She has to find a way of doing something which may not be exactly to the liking of the judges, but where she follows the law. That there is a already notice issued. Section 144 is already promulgated, or in Maharashtra, Section 37 of Bombay Police Act, already in force. Then announcement is supposed to be made on loudspeaker for the crowd to disperse. It is duly recorded, not heard by anyone. And then you actually charge his order or firing his orders. So they find ways, what they have to do, they have to reach a goal. And for reaching the goal, they follow a path or chart out a path which will not bring them in trouble with law. Of course, every day, IAS officers and executive has to face music in the court now. Because they have no other alternative. They have to show the result. Their masters, political masters, will say, what is this? How can you allow this to happen? Therefore, here also, law-making definitions fails. Situational response to by a responsible officer is all that is wanted. Situational response by a responsible officer. And what you have to examine is whether the response was situationally correct or not. जैसे डॉक्टर साहब रेनकोट पहन के नहाते हैं, so रेनकोट पहन के नहाना बराबर नहीं है. Situational response is wrong. So in the given situation, what you are required to do has to be decided, and that unfortunately is shackled, stopped by the existing legal order. So first is it is not possible to locate the norm, because not just laws are conflicting, and therefore you see, professor will tell you afterwards, every new law, he says, notwithstanding anything in any other law for the time being close, God save them. Notwithstanding anything contained in any other law for the time being close. Because the legislature is not sure. The draftsmen in the Parliament House are not sure as to whether there are any other laws covering this subject. Nobody bothers to read. They can't. If any draftsman in the Parliament House decides to read all the laws to find out whether the new provision conflicts with anything else, he will die. Not be able to read anything. Why? How many laws are there in India? Modi ji repealed some. How many? Modi ji repealed how many laws?
1,000 odd laws.
Huh?
1,000
and odd. Okay. But even after that, there are thousands of laws. Now, in COVID time, what was useful? Some antique piece of legislation became useful in COVID to curb things.
British era.
See, I have no grievance about British era laws. Not because they were British era laws. See, there is a Rigvedic hymn, yet noble thoughts from the whole universe come to us. No issue. If it is useful, we want it. But if it is useless, we don't want it now. If it is working, fine. If it's not working, simply because it is given to us, we use it. Somebody is fan of Charles Dickens here? Somebody told me, read Charles Dickens, Oliver Twist. Charles Dickens, heard of Charles Dickens?
Yes.
Who has not heard of Charles Dickens, raise your hands. Great. Charles Dickens was a great author. In every book of his, every work of his, not just Oliver Twist, Pickwick Papers, every work, you will find him criticizing the legal system, legal order in Britain. We can say that after all it is a novel, work of art. It has nothing to do with law. But that's not so. Because Dickens was actually working in a law firm as a clerk. And he knew inside and outside of Old Delhi, that is the court. So therefore, we can't write off Dickens like that. He was not speaking out of his hat. This is what we had seen actually happening. And literature is a mirror of society. It gives you the true picture. First, I quoted Jonathan Swift second is this Dickens. Both of them have condemned the English legal system in no uncertain terms. When America gained independence from Britain, what did they do for the first thing? The first thing they did was the first thing they did was to change the left hand rule to right hand rule. British keep left, no? They said keep right from tomorrow. Just to show that they are independent. They are different from Britain. We need not enter into such a trick to show our independence. But it is necessary for every society to find its own bearings, where it stands. And here we failed. Maybe because 1947 was a turbulent time, we had suffered partition. It was necessary to continue with the system. But this continuance with the system was very costly. British ruled India for how many years? Wrong. Wrong.
90 years.
Just 90 years. From 1857 to 1947. Before that, British did control India. But then, in princely states, British rule did not apply. Many princely states had their own laws. They applied their own laws. IPC applied only in British India. Like CP and there are British provinces, United Province, but not in Hyderabad, not in Baroda, not in Gwalior, isn't it? So therefore, just 90 years of British rule of all these laws, we could not eradicate or we could not examine, even examine in now this 77 years now. 24 will be 77 years. We could not examine the correctness, utility of those laws. My submission is that first there is a basic fault in the process of law making itself. That is, to control everything by a law. No. You can't have law for everything simply because life is too diverse and life develops in various different ways at a tremendous speed. Law cannot keep pace with life. Therefore, don't indulge in this type of lawmaking. Basic rules of conduct, basic nyaya buddhi, that is what is required, and that is what is missing. How do we select judges? Do we find that the judge has sense of justice? I have some of you who may be interested in some research. I have a project for you. Examine the resolutions of the collegium in the last 2 years, because they are not putting everything on them, no? And find out what reasons they have given for selecting a particular person as judge. They are all good persons. Now, no grievance about those who have been appointed as judges. But have they anywhere said that this advocate, while arguing a case, stuck to cause of justice? Said at some point of time that, my lords, my client does not have a good case. Harakiri. If an advocate says that my client has no good case, is committing harakiri. But then, what are advocates? Officers of court, no? Are they spokesperson of their clients or officers of the court? Officers of court. So therefore, what is their role? To assist the court in doing justice. But if they don't perform that role, go with the stream, what happens? This is what has happened in the last 77 years of adjudication. Unfortunately, when we gained independence, those who were working till that day as His Majesty's judges, no disrespect for all of them, they were all great men. But they had nothing to do with your freedom struggle. Till yesterday, they were convicting people for indulging in freedom struggle. That they had absolutely no attachment to the vision of our freedom fighters. We did not want to get rid of just one master for another master, a British master for an Indian master. We wanted freedom, liberty for all people. Could they think of that? No. Because they were His Majesty judges, all barristers, well steeped in English tradition. Then they selected people who were also well steeped in English traditions. And this is what we have today. Therefore, unless we change the things, see, we can't do away with the entire legal system. We can't persuade just Modi ji to repeal all laws in one go, including the Constitution of India. We can't. Because if that happens, we need to have wise people who sit as judges, isn't it? Now, imagine a situation where there is no law. In fact, English law is supposed to have grown from precedent to precedent when there was no law. So we want a just person who will be able to decide what is right or wrong in a situation. There was a sage, Apastamba in India. Heard of Apastamba?
Yes.
Yes. Very good. Apastamba said that neither Pitaras, gods, Pitaras or Gandharvas can tell you what is right or wrong in a situation. Because those situations are alike. The theory of precedent fails here. Then maybe the things are similar, but the actors are different. Time is different. Therefore, how can you apply something which has been done by different persons in different contexts, in different situations, to govern a new situation? I prefer Apastamba because of one more thing. He is not dogmatic. He doesn't say that go by Sanatana Dharma, whatever is laid down, go by it. He says no, it changes, no. Accept the change. Nothing can be decided like that. Therefore, please try to evaluate, examine our laws with reference to this. Do they answer to the requirements of the society in the present day? Saying that because it was 1872 Indian Penal Code, it's bad. Maybe, may not. If it is useful, we will continue. But what purpose it is serving? What purpose all these laws are serving? If they do not guide the common man as to what common man should be doing in a situation, if the laws are always in a flux and uncertain, let them go. And let common man decide whether his conduct is just or not on the basis of basic rules of conduct. It is said that what Lord could achieve in 10, we have not been able to achieve in 10,000. What is 10 and 10,000? What God could achieve in 10, we could not achieve in 10,000. What is 10 and 10,000? What is 10? What Lord achieved in 10? Not lordships. Almighty God, creator of all.
Created the world in 10 days. In 10 days, he created the whole world.
Yes, but he would achieve not just creation of world, he controlled people. No, what are those rules? 10 commandments. 10 commandments. Heard of 10 commandments? We did not go to see because something is Western, we did not reject it. We also have similar commandments, no? Ahimsa Satya Asteya. Isn't it? Aparigraha. What are these? Yamas, no? So, you have these rules followed. Ahimsa, don't do harm to anyone. Now, assault on a person also comes here. Or, may not be actually assault, but assault on the mind of a person. Becomes hinsa, no? Is it hurt somebody's mind? Hinsa. Asteya, aparigraha. So, if you follow these basic rules, ask anyone in a situation, have you taken something which is not earned by you? If it is not earned by you, it's not yours. Simple. It's theft. You don't have to define theft because the moment you define theft, what is the definition of theft? Which type of property? Which type of property? Theft. Definition of theft as in IPC. Yes, it has to be tangible, movable property. Okay, immovable property cannot be stolen. So therefore, forget these definitions which restrict us. Hurt. How is hurt defined? Body, mind and reputation, where does it come? Injury to body, mind and reputation. These words are found somewhere. Where?
Defamation.
Anyway, don't tax your brains too much. But understand this. It's difficult to find the provision of law. It's difficult to recite word by heart these definitions. And then restrict yourself. So therefore, move out of this. Let us move out of this. If we want to govern the society, if we want to have a just legal order, first it has to be simple. Anyone should understand what he is doing, what he should be doing at a given point of time. And coupled with sages or people who have that sense of justice, right or wrong, situational right or wrong. Many may not be, say, fans of Upper Stamba. What about Michael Sandel? Professor Michael Sandel. Heard of him? No. There is a NAU professor also sitting here, and possibly NAU has that book. What is the right thing to do? She has said yes. So, there are all videos of Michael Sandel. Can we go to net? Can we internet? Can you show something on the net? Professor Michael Sandel. What is the right thing to do? So, we of course learn yoga only when it becomes yoga now. Imported from America. So, like that, this wisdom from Michael Sandel will be more easy to digest than what Upper Stamba says. Right? So, Michael Sandel has a number of videos. What is the right thing to do? I would urge all of you to see those videos. Then you will find out how they teach conduct, right or right, wrong conduct, and how we deal with that. So, therefore, if right or wrong is extremely situational, if, as the young man initially said, tested with reference to the changing times, then we can't shackle ourselves with the existing set of rules or laws, whether made in 1872 or 1972, it doesn't matter. It's not that English legal system is the only legal system in the world. I wouldn't recommend that we go for Chinese or Russian legal system. But then there is a whole of Europe, which too is governed by rule of law. No? They don't follow English law. They don't follow English way of judicature. And fortunately in India, we had an opportunity to show some video. We had an opportunity, just a glimpse of it. We had an opportunity to see the continental jurisprudence also. Goa, Pondicherry. Pondicherry was governed by the French. Goa was governed by the Portuguese. I had the good fortune of sitting in Goa for almost 3 consecutive years, 3 months each. Time is over. No, I could gauge, without the sleep also, I could gauge that I am overstepping your time. Because the best form of flattery is, what is the best form of flattery for a speaker? Rapt attention. And what is the signal to go? Right? So I sense those signals, don't worry. So point is, you please see these videos afterwards, because we have to have some time for question answer session. You can show it afterwards, no issue. Or they can see it on their own. See, my first submission is that this lawmaking business has to come to an end. And judicial lawmaking has to stop immediately. Because our judges are really not equipped to look beyond the facts of the case. When you lay down a law, it applies beyond the facts of the case. No? It becomes a precedent, applies for future. They don't see what is the consequence of what they observe or what they see in the judgment. Adultery judgment says marriage is an institution which is antithetical to the liberty of women, freedom of women. The man condemning an institution of marriage itself. And again, for what purpose? For liberating men. How do you say that it is antithetical to the freedom of women? God knows. So therefore, inability to look beyond the situation, beyond the case, facts of the case, is something which requires that our judges should be deprived of their law-making abilities. There is a book called Justice versus Justices. Heard of it? Yes. So please read that book also. So it is justices who are against the justice. So there is another book which I recommend. Jerome Frank, Court on Trial, 1950 or something like that, published long ago. An English judge criticizing the English legal system. I wind up with the last submission to you. Heard of Ankush Maruti Shinde? Ankush Maruti Shinde's case. 6 persons were on a death row for almost 9 years, because even the Supreme Court had sentenced them to death. And after 9 years, it was found that they were innocent persons. So on fact finding also, not just application of law, on fact finding also, our system has failed. And if we still want to cling to that system, you can just imagine how disastrous it will be your future. Because you have to lead your whole life. Therefore, examine all this carefully. And if you feel that yes, something needs to be done, it needs to be done now. We are already late by 77 years. Now, at least by 2047, when we celebrate 100 years of our independence, we should be having a flexible legal system, a flexible adjudicatory mechanism, which ensures that justice is promptly done. We have a just legal order. So thank you for inviting me to this session. And if there are any questions, I promise not to answer them. Go ahead. I promise not to answer because I don't want to bore you further.
Good afternoon.
Yes.
So I'm Ashutosh from Dr. Babasaheb College of Law. So I'm to ask, so do you think that jury system should be brought back in? As we say, that crime is committed and is public. It's a public crime. That's why state is the part. And state comprises of the public. Do you think juries should be brought back in?
The concept of jury system is this. Facts are decided by jury, not by the judge. Judge decides the law. Jury comes with a factual finding and judge decides the law. You have seen that एक रुका हुआ फैसला, एक रुका हुआ फैसला, नहीं देखा? देखो. जिन्होंने नहीं देखा वो देखते. See, jury system is good because facts are decided by people who are in the society. But then there were many problems. First is, for any reason, if the jury was disbanded, a fresh trial had to be held from the beginning to end. And therefore, that system was disbanded. But now see what we have replaced with that system. We have a judge who decides everything. Now, many of you coming from a background which is altogether different, don't know the mores of the people who have come up before you, isn't it? So therefore, you judge them according to your standards. Therefore, it's necessary to have common men deciding facts, or at least assisting the judge to decide facts. When we had this new system, the judge was supposed to be hearing the entire case. But now, examine because the entire data is available on the net. I urge some of you to examine how many cases are there where the trial judge has not even heard the entire case and sentenced persons to death or life imprisonment. My son, who is practicing lawyer in Bombay, said that he came across a case in which not a single witness was examined before that session judge who delivered the verdict. What is the point? He has not seen any witness. Therefore, there is no harm in bringing back the jury system without its ills. For example, fixing the jury, objections, etc. All that, we have to find a way out. We had panchayats in the past, no? So therefore, it's not that this is new for us. But I think that it is time that judges who don't know anything about the society stop talking about the society. One example I'll give you. There was a case of a married woman wanting to walk out of the husband's house and seeking maintenance. She was a daughter brought up in a home where the parents would also never scold children. They would always say, "Bete, आपने खाना खाया है? Bete, आप जरा अपने shoes उतारोगी?" So this was the always respectful to your children. Okay. So her husband was an Air Force officer, and once she put a little more salt in the kitchen which she made. Mother-in-law was suffering from hypertension. His husband got annoyed and slapped her. One slap only. Bad enough. So she wanted to walk out of the house. So just said, "What is there?" Only one slap because justified reason. What is there? Why should we walk out? But she was brought up in a society where this was not tolerated. This was not expected. Another instance. Those stonebreakers. A stonebreaker's wife was beaten by him with a wire rope. That is, rope which is used for tying clothes. So, different norms we have to apply here. She had children. Here, she did not have children. So, if this woman walks out of the life of that stonebreaker, where does she go? What does she do? Husband was drunk, he beat her, no doubt. But here, what was necessary was reconciliation. Stay together, work out something. Because this is your way of life. All of you drink. This happens. Your children don't drink. So, otherwise, our judges giving advice from the dais to a rape victim. And marry, what is that? All this happens because we don't have that connect with the society. And therefore, connect with the society is important. I agree with you apart. Yes. Yes, please.
Good morning, sir.
Go ahead. Fire.
Good morning, sir. My name is Sarah Kubre. I am from Narayan Law College. Sir, is the sanction type of punishment? Is the sanction type of punishment? What is the difference between sanction and punishment?
Sanction and punishment. Yes. Please. What is the sanction? Disapproval of other society. Right now, society's disapproval of a conduct is a sanction. Correct? Right or wrong? What is sanction?
Depriving to do any act.
Yes. So that is disapproval of the society for a particular conduct. Don't do it. And punishment is imposing a fine, penalty, or imprisonment. Right? Now, we have restricted ourselves because we have made laws. No? We have restricted ourselves with punishments, fine, imprisonment, death. This doesn't work in practice. Have your college authorities taken you to prisons? If not, please visit prisons. Please visit at least the open prison at Paitan. Talk to people who are life convicts, who are suffering life imprisonment. You get a lot of wisdom from them. So therefore, punishment does not always work. In the best of times, deterrent punishment. Now what happens is legislature, they have a knee-jerk response. A women's organization takes out a morcha. Stringent punishment for rapists. There's a death. Hang the people. But this doesn't work because nobody is hanged. No. The moment the punishment is hanging, the judges are also reluctant to hang. Evidence also has to be scrutinized strictly and it goes through a hierarchy of courts. By the time, nothing happens. In best of times in Britain also, when there were public hangings, again Dickens, public hangings for even pickpocketing. So, when a person was publicly hanged for pickpocketing, there were pickpockets operating in the crowd. Though they are seeing that a pickpocket is being hanged, they would pickpockets there. Deterrence works only if it is executed fast, and that is not done in India. Yes, please. There was another, yeah, please. No, get some voice and chance.
This one.
Good morning, sir. I am Aditi Prangarkar from RTM Dr. Babasaheb Ambedkar College of Law. And my question is quite basic one, sir. So, it's relating to a name of the topic, transition to a just legal order. So, I just wanted to ask you, what is the purpose of the word just here? Because you can go with legal order also, not transition to just to legal order. So, what is just?
Great question.
Thank you so much.
Background one. If I say, सर्व रामायण झालं तर सीतारामाची कोण असं विचारलं. So, that is just a minute. That is not just that just. Just a minute. So, please. The whole problem is with the just. And therefore, Apastamba says that what is just, what is right, is extremely situational. You can't decide what is just for all times to come. Just legal order is one which takes into account the need for having flexible laws and a quick enforcing machinery, an efficient machinery to enforce. That is a just legal order. May I repeat? A just legal order is one which does not shackle law, shackle the society with law, does not restrict law with definitions, keeps them flexible to meet the situation as it arises, one, and two, has an effective, efficient machinery to enforce those laws, to seek compliance. That is a just legal order. And on this test, does our present legal order pass or fail? Tell me.
How can I decide?
You are the Chief Justice of India for a moment. Take it like that.
That's all, sir.
Yes, please. Young man, ultimately you get a chance.
Good morning, sir. Myself, Kaustubh Bhullar from Bombay College of Law. My question is, sir, judiciary is often said that it is controlled by rich, wealthy, and influential people. They can get away with anything, like we have seen in recent cases. And one case I personally saw that one of the ruling party minister has crashed. So during farmer registration, he crashed with his car. His own son was convicted in that offense. Within 6 months, he got released in that. And other topics are, so just I want to remarks on collegium system, which is old and very often it is said that it is a nepotistic, as father and son or blood relatives. They are often get into the judiciary without any merit. It is often criticized, so it is not my personal opinion, because I have read some articles over it. And the judiciary, the most lesser talked about topic is judicial corruption, which is also a big hurdle to the what we have. What the topic is, a transition to just legal order. If we have transition in this into the just legal order, so we have to overcome these hurdles. But basically, the judicial system, this major reforms should be taken place. What are your opinions on this? Thanks.
See, about politics, let us not go into politics, that will be a separate topic. About the collegium system, I have already requested all of you, please examine the resolutions of collegium in the last 1 year and you will find what is what. What I suggest is, we need to have an objective system of selection of judges where the performance of the candidate prior to becoming judge will be scrutinized with reference to record, which is fortunately available now. All the cases are on web now. You can find out how that advocate has performed. And let us set the standard by say applying it to Justice Chandrachud himself. Okay? When Justice Chandrachud was practicing at his whatever cases he argued, no, those judgments are there. No? So we know, we set that standard. This is the way that judges have been doing. And then we can change. As far as nepotism, etc. is concerned, yes, maybe it's there. But then I also became a judge. None of my family members had anything to do with lawyering. And the only brush that my parents had with courts was when they were sentenced to imprisonment in the 1942 agitation. That's all. Otherwise, we had no connection with law. But I became a judge now. Therefore, it's not that that everything is bad. But we need to struggle. We need to change. We can always suggest good changes now. So therefore, evaluate the performance of it. There is a book called Court on Trial by 3 researchers based on data. Please read that book. Now, nothing can be put under the carpet. Okay? Therefore, entire data is available. Find out how judges have performed. Find out how judges have performed before their evaluation. Keep it. Yes. Now, I suppose time is up.
Yes, sir.
Thank you.
Due to time constraints, we will not be able to take any more questions. Thank you.
Thank you.
Thank you, sir. It was a very thought-provoking and interactive session. A session because of which participants have taken a step forward in their everlasting legal journey. I would like to thank all the participants who have attended the session with a whole lot of enthusiasm. Last but not the least, I would like to thank all of my team members from Vidimanthal who helped us to conduct this session. Now, I would like to invite Dr. Ravi Kaur sir to provide Honorable Retired Justice R.C. Chavan sir with token of appreciation on behalf of Vidimanthal.